Cool. Looks like we are now live. So good afternoon or good morning, good evening, depending on when you're watching this. Today, talking with Babs Jamieson, founder of Jamieson Law. And yeah, we'll be talking about a number of topics ranging from IR35, the obvious one, to contracts and the legal things that you should look to put in place as you start out on this consulting path. So Babs, thank you very much for taking the time today.
No problem at all. Thank you very much for having me. I'm delighted to be here.
No worries. Do you want to kick things off for the group? Just give them a bit of an introduction about yourself, your background, etc.
Of course. Well, as Matt said, I'm Babs. Don't be fooled by the accent. I'm actually a UK solicitor. I advise clients in Scotland and England. But yeah, I run my own law firm. It is kind of geared towards small businesses and startups. A lot of our clients are consultants, freelancers, in that kind of field, and dealing with obviously a lot of issues, particularly at the moment, particularly with IR35. But on an ongoing basis, we deal with a lot of contract reviews and putting in place terms and conditions for contractors. We do things a little bit differently at Jamieson Law. Everything we do is fixed fee, very transparent. We're very kind of commercial with our advice. Our clients have our numbers. They just give us a ring and check something. It's not like a kind of traditional law firm where you're terrified to pick up the phone in case the invoice comes in and scares the hell out of you. So we do things a little bit differently. Try to be the kind of friendly law firm that can help you kind of navigate through what you should be doing and what you shouldn't be doing, just to kind of make sure that when you're going out on your own, that you're not running with risk that you shouldn't be running with, and how to minimize that. So yeah, that's me.
No, that's fantastic. And I think, yeah, speaking from my own experience, I've used those law firms in the past and regretted it, where every conversation has an hourly rate associated with it. You're not entirely clear what you're getting out the other end. Is it really bespoke? Is it off the shelf? But you know that you're paying an awful lot of money for something you don't entirely understand. So I think, yeah, your approach is a refreshing one and a much needed one.
Thank you, Matt. That's the goal anyway.
Yeah. No, that's really, really good. So again, yeah, should we kick things off with the obvious timely topic of IR35? Why is that such a big issue at the moment?
Well, I'm sure a lot of your listeners have been kind of banging their head against the wall with this for a bit of time, or maybe some of them are just kind of now realizing, depends if they're how new they are to the IR35 and the contracting world. But basically, the IR35 rules have always kind of been in place. They're otherwise known as the off-payroll working rules, or the disguised employee rules. I actually calling them the disguised employee rules answers a lot of questions that people have. It's basically HMRC trying to make sure from their perspective that they are properly taxing people that should be employees. So now this, don't run away in fear when I say this, but if a contractor is working for one client for 4 years and they're taking money through their company and aren't actually paying PAYE and national insurance in the way that a normal employee would, that's the kind of person that HMRC is looking to kind of to bring action against, to make sure that if people are genuinely running a third-party supplying business, that they can have the tax breaks that come along with having a company, and they can be taxed accordingly. But if people are pretty much carrying out the role of an employee but just happen to be doing it through some sort of intermediary, that's where HMRC are looking to step in. On the 6th of April, so start of the tax year, the IR35 rules changed. So the burden was previously with the contractor, the freelancer. The burden is now with the client company. So essentially, if HMRC find that there's an issue, it is the client company that will be fined rather than the contractor. So the rules themselves haven't particularly changed. It's just that now that the clients have to pay for it if it goes wrong, there's obviously a little bit of jumping up and down in the industry, and it's causing clients to, well, they have to undertake status determination assessments. They have to make sure that they're very, very clear if you're inside or outside the IR35, and you're paying the appropriate tax that you should be paying.
Yeah, and I think that's the interesting thing for me, is that a lot of contractors obviously making a lot of noise about this at the moment, understandably. But
Yeah.
previously they were in a riskier position. You could very well argue than they are in now.
Yeah, I mean, the risk is increased now in terms of clients not wanting to contract with them.
Yeah, exactly.
That is the risk now. But from an HMRC perspective, no, like contractors have actually never been in a better place.
Yeah, no, I think it's interesting. So for me, I think it's, I always say there's two types of contractors. There's the type of contractor that really did go client to client, was quite happy working in that way, and that's all they wanted.
Yeah.
Then there's the second type of contractor, and this is the position I was in a number of years ago, that are actually trying to run it and grow it as a genuine business. So for me, my interest has obviously always been in that second camp, and I think the market conditions changing, I think, is perhaps forcing people to think about which of those two scenarios is right for them.
For sure. And I mean, we can come on to that in a little bit more detail if you'd like. But I mean, if it's the latter, as you said, Matt, I mean, this is the time to be really branching out your business, creating a website, having marketing strategies, doing the things a normal business does. Because what you don't want is to be pulled into that first category when you are genuinely trying to provide a third-party service to clients.
Yeah, absolutely. And I think the risk, as we said, has changed from HMRC risk to risk of opportunity. So I would encourage people to, if this is what they want, if they want to remain outside of IR35, if they want to run a business, should be the question. If they want to run a business, then IR35 shouldn't really be a consideration. But if they just want to go client to client, then you could argue that inside IR35 could well be the right determination in those cases.
Yes, absolutely. And yes, you'll pay tax as an individual, but you won't have HMRC or your client breathing down your neck, and you are likely to have more opportunity, to be honest. Clients don't want to run that risk.
No, absolutely. So I think, obviously my approach is firmly in favor of growing that as a business, differentiating yourself, working out what your consulting product set should be, and then trying to grow that opportunity, because needs are always there. They haven't miraculously gone away since the 6th of April. So there is a big opportunity, I think, as you say, to position yourself differently to those clients. Yeah,
absolutely. Totally agree.
Yeah. So if someone was going down this route then, and previously maybe they've been going client to client, maybe a little bit of freelance work on the site, but if they're now thinking of running it as a proper business, then what are some of the legal things that they should be thinking about? Terms and conditions, contracts, all those kind of things have likely been not an issue before, not considered before.
Yeah, I mean, most contractors, freelancers that haven't really thought of the kind of being a separate business on your own account type of approach, most of the time are just dealing with the contract that is coming from the client. They may or may not get a legal review of that contract, but they pretty much just sign up to it like they would an employment contract and don't think too much about it. Now, that's not to say that won't happen if you're running your own kind of established business. It will, depending on the size of your client, they probably will still want to use their document. But I would always recommend that you have some sort of legal review of that document, just to make sure that you're clued up on what you're signing up to. Definitely the best approach is to have your own customer contract, your own client contract. The way that I think it's best for contractors to do is to have a document where you kind of got your standard terms on the front half, or even the back half, depending how you want to work it. Have it in the front half, and then have like a schedule at the back. That's the only part that you need to amend for each client. So it should set out the package or the service that you're wanting to provide, how you charge them, or you can have it the other way around if you want to do a statement of work. Whatever approach you choose to do, I think it's really important that you keep your standard terms standard, and that you just doctor the specific services and the specific fees depending on the client. Now, that's not to say the client won't negotiate things, and they will. From your perspective, from an admin perspective, from a risk perspective, it's easier if you can, broadly speaking, know what your terms are for each client. It allows you just to manage that that risk a little better.
Yeah.
In terms of the contract itself, even if you are running a third-party independent business and it is legit, you still want to have certain kind of IR35 safety wording in there. So things like, this is a third-party supplier, this is not an employment relationship, you're not subject to the supervision or direction or control of the client. I don't like references to timesheets in
Indeed.
These kinds of contracts. That looks to me like an employment situation. You'll tell from the kind of feel of the contract this is relevant to a client's own contract or your own that you're drafting. But you'll get a feel from the contract as to whether it feels like an employment contract or a third-party supplier contract. If it's a genuine third-party supplier contract, there should be no reference to things like holidays, sick pay, time off, anything like that. Even policies and procedures is a bit funny. If you're being asked by a client to comply with anti-bribery and modern slavery, that's fine. But if you're being asked to comply with time off procedures and how to conduct yourself in the workplace, all of that is a bit employment-like. So unfortunately, it's not science, it's an art, but you should be able to get a general feel from the contract as to whether it feels like a legitimate third-party contract.
Yeah, absolutely.
Your contract is the most important part. That, if you're going to do one thing after listening to me, is the thing I would tell you to do, is to make sure you have a really good bulletproof contract in place, and not just to protect you, but to give the feel and the tone and just set the kind of environment for the working relationship. Your contract should reflect you. It should reflect your tone of voice. It should reflect the conversations that you've had with the client up till now. Yeah. You don't want to, be pitching for work and be this really friendly, bubbly person and then give them a 40-page terrifying contract that they have to put through legal.
Indeed.
It breaks down the relationship. It could cause you to lose the sale. None of that's what you want to do. So in a lot of ways, it's almost as important to make sure that the contract that you're putting in front of clients really kind of properly depicts your brand and what you're trying to portray to the market.
I think that's really interesting. And I think I've made mistakes in the past having, like you say, that 40-page legal contract drawn up that, to be honest, I didn't completely understand it. I'm pretty sure my clients didn't completely understand it either. And it was very, very heavyweight. There were so many de-risking measures in there that it was, scaring clients off from working with me, to be honest. Yeah.
And that's the thing, like most contractors probably need maybe a 6-page document max.
Yeah.
And one of those pages sets out what you're doing and what you're charging. You could probably get it down even lower. It depends what kind of consultant you are, what kind of service you're providing. Obviously, if you're doing some sort of like FCA regulatory advisory services, you're going to have more in your contract than if you are advising on maybe marketing and social media, although there are risks with that as well. But it's totally dependent on the industry that you're in. But I would always say try and keep it light and in your tone of voice and cover what it needs to and de-risk you where it needs to, but don't send them off running away terrified at the same time.
Yeah, no, absolutely. And I think understanding how you want to deliver your products and services is critical, and then make sure that the contract reflects that, and as you say, sets the tone of that working relationship as well, doesn't it?
Absolutely. Yeah, that's almost just as important.
Yeah, I've seen contractors new to consulting that still turn up with that employee mindset, and they go through contract negotiations and all the rest of it, but then on the start date they default to letting the clients tell them what to do. They're turning up for work rather than actually working with the client to deliver their product, their service in the way that they've defined. And I think that's kind of related to the contract in a way, because it does define that working relationship.
Absolutely. That contract of yours should read as you are a third-party supplier providing your service to the client because the client has decided to buy that service. It shouldn't read as if the client is hiring, needs to fill a gap in their organization, they're bringing you in and they're just going to throw tasks at you. That's not what your contract should look like.
Yeah, absolutely. So if the client is, so ideally you want to have this contract yourself. If the client also says, but we also have a contract that we normally issue people in this scenario, how would you approach that contract in that situation?
Totally depends on your bargaining power and how much you want/need the client.
Yeah.
If you're desperate for work, if you're really desperate for that client, take the contract, get a legal review done. And when you send it for legal review, make sure that the remit you're giving to the solicitor is highlight what I can't deal with or things that I need to be aware of. If it's a really high ticket client or a really important client to you, what you don't want to go back with is a really heavy markup, because you may as well have enforced your own contract in the first place. It's just going to annoy them. Again, it's going to break down that relationship when it's still in the sales stage. So, I mean, they don't have to take you on. They could just turn around and say, do you know what, this person is too much like hard work. So I would encourage it to be a light legal review, highlighting the areas of risk to you. See if you can deal with those areas of risk yourself. And if you can't, go back and explain why the changes need to be made. If you are in demand, if you don't need the client, if they feel like they might be a little bit difficult, or if you are actually in a better position than them. So for instance, if you're if you're really well known in the industry and you are the contractor that people go to for X, Y, and Z, push your own terms. Say it's bargaining power, and you don't need the work. So I would definitely say to them, these are my terms and conditions. Have a read of these and let me know if there's anything that you're not comfortable with.
No, absolutely. That makes perfect sense. I think I have seen some situations myself where I've issued a consulting client a contract, but they've also felt they needed to send a contract as well. But we made it clear in that situation that their contracts, the important bits were there really about covering their intellectual property. That's what they actually cared about from their contracts, in which case I was happy to sign that tiny contract in comparison to protect their IP, as long as they were willing to sign my kind of services agreement contract as a supplier to them. And I think that was a good balance.
Yeah, it can be things like that. Depending on the client, it can be things like IP, it can be confidentiality. A lot of the time, as you say, it can just be dealt with by an NDA that sits alongside it, or you can make a change to your own contract, lift some wording in that makes everybody comfortable. Yeah.
No, absolutely. That makes sense. Are there any other kind of legal documents or considerations that consultants should be thinking about, in addition to that contract?
Yeah, so a lot of this will depend on the kind of age and stage of your business. Not really legal, but make sure you have your PI cover in place. It's really important that you have professional indemnity insurance. People tell me lots of reasons why they don't need it, and none of them wash, quite frankly. You should have professional indemnity cover. And that's, I'm never saying that from my interest. It's if you get sued, you're going to want that there, trust me.
Yeah.
So that's really important. As a business owner, you should be registering with the Information Commissioner's Office if you're UK based. So I think it's ico.org.uk off the top of my head. You should be paying roughly £40 a year, and that is to notify the UK government that you're processing personal data. Now again, people tell me that they're not. You're always processing personal data. Even if you just take someone's name and email address, you're processing personal data. So you should sign up on that website, make sure you've done that notification, you've paid that fee, and you'll get an annual reminder to do that. So you should just keep that going for as long as you're operating the business.
Yeah.
As well as that, you might want to consider trademarks. Now, this really will be where you're running a business. If you're running a, I did run a consultancy firm a while ago, and it was Babs Jamieson Limited, and I had literally no interest in trademarking my own name. But if you are running a legit business that you're trying to grow and scale, it's really important that you consider trademarking the name or the logo or both for your business. If you're UK based, you're probably going to want to start off with a UK registration. The important part about that is not just that it stops other people using your name, but it actually stops other people coming along and registering that name and then stopping you using that name.
I see. Yeah.
It can be a more important part. I spoke to a girl a couple of days ago who said, "Oh, I don't care if somebody else uses the same name. I don't really have a problem with that." And I said, "Yes, but you would care if they registered it and then served a legal letter on you and you couldn't use it after all and you had to rebrand."
Absolutely.
So that's a really, really important part. As your business grows and scales, your IP portfolio almost becomes a separate revenue stream. You know, and now this isn't fully applicable to a lot of consultants, but it could be if you're looking to attract investment or you try and sell the business or anything like that down the line. If you don't properly own your IP, your copyright, your trademarks, you're not going to be able to sell, or you're going to have to sell at a far reduced price. And on the other side, if you've got it all done properly, it's likely to push the price or the investment up. So that's something really important to kind of bear in mind as well. And the UK process is not terribly expensive.
No, that's really interesting. I think that's something that a lot of people definitely overlook. You know, even if they are, you know, a little bit further on in that process, they've got their own systems, frameworks. You know, they've got their own product brand as well as company brand. It certainly is worth looking into.
Yeah, for sure. And then just off the back of that, and it kind of relates back to client contracts, but you want to make sure you own all the copyright in all of your work as well. So you want to really make sure that the IP wording in your contracts properly states that you own your processes, procedures, know-how, methodologies, all of that. Now, it might be the case that you're happy for the client to own the end product. That'll be kind of dependent on service you're providing, but you still need to keep the background knowledge and you know, the underlying know-how that goes into that. Yeah,
I think that's a really, really good point, because I think a lot of contractors beginning that consulting journey, you know, if I work with them, we do develop those methodologies, those frameworks, etc. And I see contractors that are just so used to like giving with the right intentions to the clients that they almost want to give too much of that away. I feel not just the end result, but you know, almost not stake any claim over the things that should be their IP, that should be the value add to their business.
Yeah, and I mean, is this going to happen? Hopefully not, but there's always the chance that, you know, you create something for client A and then you use the same processes and procedures to create something for client B, and client A comes along and says, well, now we own that actually, because check your contracts, you can't sell that. And then your whole business gone. So it's really important.
Absolutely. I think, that's definitely a clearly very important aspect of it. But I think also, you know, I've seen situations where clients almost try and get you to modify your IP and stake some kind of claim over, oh, can you just change this? Can you just do this for us? Can you do that for us as well? And it blurs that relationship again, I think.
It does, absolutely. If you're going to protect anything, protect your IP.
No, absolutely. And I think, the other point you mentioned as well about, you know, managing personal information, I think is something that a lot of people don't consider enough. Like, you know, every email conversation, etc. You know, you have people's information there, and as you try and, you know, expand the reach of your business as well, you will be doing, you know, marketing activities and gathering more of that data.
Absolutely, and you really need to make sure as you are growing and scaling that you are complying. I was going to say with GDPR, but it's now just the UK Data Protection Act, since we're no longer part of GDPR. Same rules and everything still applies for now. But it means that, you know, when you get a website or an online presence in any way, things like landing pages and other kind of funnels, you should be having privacy policies, cookies policies. If you are capturing email addresses, sticking people on an email marketing list, you need consent for that. As you grow, you should probably at some point have an internal policy document that explains to you and kind of any staff that you may have what data you're collecting, why you need it, what you do with it. It means that if you're ever challenged by the regulator, you can say, this is the data we hold and this is how we look after it. And then there's just the standard things about making sure you have antivirus on your computer, keeping things in secure drives, not emailing things out to personal email addresses, all of that kind of practical stuff that we all know that we're meant to do, but we really need to be doing. Yeah, no, absolutely. I think, as you set up those marketing systems as well, it's easy to use a lot of the big suppliers that are US based that probably don't have the mechanisms in that you need to actually get that consent in the right places, etc. That's right. I mean, the US has the California Consumer Privacy Act, which is like baby GDPR. It has a lot of the same principles, but it's nowhere near as stringent. And the US did have this big ambition about moving it across all the other states, but it's, COVID and everything, it's not happened. So as you say, Matt, not everything, but a lot of the things you get from US providers just will not be GDPR compliant. Yeah, absolutely. Yeah, I found myself trying to, be more compliant, but actually, comply fully with those regulations, a while ago. And I certainly had to change some of the systems that I was using because it just wasn't letting me, record those things as they should. And it's not something you can go back and change after the fact. Yeah, absolutely. For sure. Do your due diligence. Yeah, no, absolutely. Cool. Fantastic. And I think there's a lot of great advice there for contractors, especially people wanting to move into that kind of consulting model, run it as a business. I think the key points are be confident in the product and service you've got and have the right contracts in place that supports your way of delivery, which I think, as you say, should address a lot of the IR35 concerns in the first place, but more importantly, means that you're actually operating as a business. Yeah, for sure. Yeah. Any parting thoughts before we go? And I'll share your details in the comments as well, so people can connect with you on LinkedIn, etc. as well. But any kind of advice you would give to people in this situation? Yeah, I would just say, a lot of people don't do this stuff because they think it doesn't apply to them, or they're too small, or it'll cost them too much money. I can't speak for other firms, but most of what I've mentioned there is going to be in the kind of a few £100 range. Now that is nothing compared. I don't know if you've ever been sued. It's horrific. As a if you're a business owner, as you grow in scale, you will suffer from legal action at some point, and it's actually kind of a sign of success. But if you sort this stuff out initially, it means that the legal action is much more likely to go away. Whereas if you don't, you're then paying thousands in legal fees. There's a lot of distress and angst involved, and it can take a lot of your time and energy. When if you'd forked out that few £100 in the beginning, it wouldn't necessarily have happened. So I would look at it. It might seem annoying and a bit of an outlay at the beginning, but it is actually just setting you up for a much more relaxed and comfortable journey as you go along. Yeah, no, I think that's great advice. I don't think it's going to be as costly or as scary as you perhaps think it is. Yeah. Oh, it's not. If you go to the right solicitor, it shouldn't be at all. No, perfect. I think that's a great way to end it. And as I say, I'll post your details below if anybody does want to connect with you as well, which I would highly encourage if they don't have those contracts in place as well. So thank you once again, and I'm sure we'll have a follow-up at some point in the future as well. Perfect. Thank you very much for having me. No worries. Thank you.